Same scenario, same problem-solving scenario we've talked about several times today. The first thing is identify the scope of the problem. What rule is it that is not being enforced? People are not cleaning up after their dogs. Good example. Last example. Who should address the problem? Should the board address the problem? No. The board are volunteer people. They don't have time to do it. They've got a thankless job and they're already spending more time than they should have to. Which leads to an explanation as to why board members don't get paid. Everybody thinks it's because of financial reasons. The reality is board members don't get paid because they cannot pay enough to be on an association board. So the board should be addressing this problem. If you're a self-managed association, that's one of the problems you're going to run into. Is you're not going to have somebody to address the rule problem. And then you run into problems with consistency and enforcement. Because it's a lot harder to call your next door neighbor out with whom you socialize all the time for not cleaning up after the dog than it is the person down the street who you don't like anyway because you don't like the kind of car they drive. So you run into problems with lack of enforcement, which is one of the real advantages to having a professional management company or a outside management company is they get to be bad guys. That having been said, sometimes problems can best be solved by a simple communication between the board and a member. If you think that the member is not complying with the rule because they don't know about it, you're going to have a lot better community if you walk up to a person and say, hey, you're new in the neighborhood, did you know you're supposed to take your garbage can in on Tuesday mornings? As opposed to having them, get a letter from the manager or the lawyer or something like that. Another good source for a lot of problems, if you've got problems with dogs running around, rather than the board be the bad guy about that, call your local dog catcher, have them swing by. If people's dogs are being picked up by South Jordan here at Daybreak, Daybreak doesn't get blamed for it, but the dogs get watched. And then, if communication doesn't work, then you're going to want to have the communications with the letter and the like. And in connection with rule enforcement, for purposes of maintaining community, you should always start at the least confrontational level, which is why if you can talk to somebody, if you think it's just a miscommunication, it's best to talk to them. If you don't feel comfortable talking to them, a lot of management companies will have pre-printed door-hanging cards that have the association's, the association manager's company name on them, and will have the contact information, and you can put the individual manager's name on it. You're driving down the street over here, you see somebody hasn't taken their garbage can in, you jot down your name, you put a little thing on their door that says, did you know that you need to take your garbage can in by X o'clock? If you do that, you should keep a record that you did that so that you know to take the next step. There are apps for BlackBerries and for iPhones and for Androids sold by community association management companies. If you go to the National Convention, they sell this stuff all the time. It is basically an app where you can go and punch it in and it sends back to your office that you posted that on so-and-so store. They even have more advanced apps where you can do that. You can put in garbage can violation, you send it back, and by the time you go back to the office, there's a letter generated to that person saying you violated rule such and such. So, making the rule enforcement process simple, but not maybe too simple, because it takes out that human element and you become a police force. So you want to go through those steps. After the door hanging card doesn't work, you're probably going to have to send a letter. And the letter is going to have to say you violated such and such a rule. In light of that, our rules provide for the following sanctions. It's going to have to set forth what the sanctions are. And this is where it becomes very important to know whether you are a condominium or a HOA, PUD, whatever other term you want to use for non-condominium. Because, and I'm going to have to step out of my work are two different statutes in Utah. And that's really small and difficult for you to read, and I knew it would be, so I printed some out. Probably didn't print enough out, but I will post this for all of you. And it's a matrix that I put together on two statutes that have been adopted by the legislature dealing with fines and how you can lien fines. It's very important to know these distinctions because there's a very big law firm that got themselves in a lot of trouble not knowing about these distinctions. And they liened an association the wrong way. They walked into court saying that their lien was valid. It was a non-HOA attorney. The HOA attorney said it was a wrongful lien, and they got significant fines assessed against the association, which they ultimately paid on behalf of the association because they didn't put the lien right. If you're going to enforce your association's declaration by virtue of a lien, you have to follow the appropriate statute. If you're a condominium, you need to follow 57-837, which is in the Condo Act. If you're an HOA, a non-condo, you have to follow 57-8A-208. 57-837 was adopted in 2001. 57-8A-208, dealing with other community associations, was adopted in 2006. They're quite similar, but they're very different. And I give John Morris all the credit in the world because he's the head of the Utah LAC and he's dealing with the legislature and things like this that make me convinced that I can't deal with the legislature because it drives me crazy. Because why they didn't in 2006 just adopt the same language and say it's the same for community associations, I don't know. I'll probably never know. But it's part of the reason that John and others have pushed for a uniform act because it creates significant confusion. And it's even worse in a situation like Daybreak where you have a master association, which is an HOA, and then you have a condo association, which is a sub-association, and a community association. Which one do you comply with? You know, you never know. You have to be very, very careful. But the distinctions to keep in mind. First of all, if you are a condo, you have to have a specific provision in your governing documents to allow fines. And if you don't, you can't, well, you can fine, but you can't impose a lien on the fine. So that's the first step. If you're a condo, you're going to have to get in your governing documents, not just a rule, you're going to have a fine. For HOAs, you can have fines unless it's specifically prohibited by the declaration. And for those of you who didn't get a copy, that's what all this right-hand column says, is these details. The other deal, in 2008, or in 2006, they did clean up the language. They made it read better, but in so doing, they changed it. Down in section 3, it talks about the fines. If you are a HOA, it has to be an amount commensurate with the nature of the violation, whatever that means. I don't know what that means. Nobody really knows what that means. It sort of means you can't charge somebody $500 if they don't clean up after their dog, probably. But where's the spectrum in there? We had an association that had a prohibition against keeping your RVs or your boats out for more than 24 hours. And the fine was pretty significant because people who own RVs and boats, they're willing to pay $50 to not have to take their RV or van back. We actually had small claims enforcement and had this issue addressed by the Justice Court judge as to whether or not it was commensurate with, that was the argument. The problem is, we walked in there, the judge, the justice of the peace, it wasn't a judge, it was justice of the peace courts. So anyway,
just one sheet.
One sheet, yeah, one copy. The justice of the peace, I walk in there, pro se person on the other side. The justice of the peace starts out by saying, I'm going to forewarn you, I'm a boat owner. So, sort of knew I was in trouble then. He thought the fines were excessive because he's a boat owner. But anyway, in a HOA setting, remember it's got to be relative. In both such settings, it should be relative to the nature of the fine. It just makes sense. But in connection with the condominium, you can only do $500 per month. Cumulative fines for a continuing violation may not exceed $500 per month. The dog I was talking about up in Park City where the person was paying $500 a month, he was just blatantly taking his dog out. The fine was $50 or so every time. They were seeing him 30 times a month. They'd hit $500 a month. That's why they had to stop at $500 a month. So keep that in mind. If you're a condominium, you can't go more than $500 a month. That having been said, even though there's no actual limitation set on how much you can do if you're a homeowner association, if you're going to charge more than $500 a month, I'd be careful because some crafty lawyer is going to either be confused and say you're violating the Condo Act, or they're going to argue it by analogy and say your fines are excessive. So you're probably stuck with no more than $500 a month in fines. The other reality is if you're charging that much in fines and it's not getting the person's attention, you're probably going to need to do something else besides just fining, because for whatever reason the fines aren't paying attention. The other big distinction here between condos and homeowner associations is in the condominium realm, a unit owner has 30 days after a hearing, you have to have a hearing, and then 30 days after that they can appeal the hearing, and then up to 180 days after that they can file an action in district court. So in the condominium setting, you shouldn't be filing your lien until 30 days after your hearing, because they have that period of time to request the appeal of the hearing, if you will. So you have to have a hearing under both of these statutes. You have to have a hearing where people can raise their concerns. They say, it's not my dog was insane, it was the neighbor's dog, it was the neighbor's insane dog, whatever defenses they want to raise to the prohibition, they have to have that hearing. About 90% of the time, they're not going to have that hearing. But you should always have the hearing. The letter that goes out to them, the ultimate letter should say, we believe you violated this section. We're going to have a rules enforcement hearing on such and such a date. Please be there and invite them to come and present their evidence with respect to it.